Hello guys, welcome back to another topic. So friends, today in this video I am going to share with you very important information as to what are the void marriages and what are the voidable marriages. We will see the difference in both of them, because if we have already seen that in terms of section 5 of Hindu Marriage Act, certain essential conditions to be followed for declaring a marriage to be valid under the Hindu law provisions. But if there is any violation of it, it will be declared as void ab initio, void marriages, voidable marriage, and or void ab initio from the very beginning. So friends, today we will see the general meaning of from the examination point of view. If you are new on my channel, please don't forget to subscribe so that you will get all the new upcoming updates on this channel. So firstly, we see what the provision says regarding a void marriage. So in terms of section 11 of the Hindu Marriage Act, any marriage solemnized after the commencement of this act shall be declared as null and void, and may on a petition presented by either party there to be so declared by a decree of nullity if it contravenes any of the conditions which is specified in clause 1, 4 and 5 of section 5 of Hindu Marriage Act. Section 5 of Hindu Marriage Act basically provides the essential conditions to be followed for under the Hindu marriage. So a marriage will be void ab initio on the basis of 3 grounds, which is already governed under section 5. First one is bigamy. If any party to a marriage has a spouse living at the time of marriage, it is declared as bigamy and is punishable and is declared as a void marriage. Second is prohibited degree of relationship. If the parties are within the degree of prohibited relationship under the custom or usage governing each of them permits such a marriage. Third is sapinda relationship. If the parties are sapindas to each other, unless the custom or usage governing each of them provides, such a marriage is declared as a void. So the next is voidable marriage. What are the voidable marriages? In terms of section 12 of the Act, because section 11 provides for void marriage under the HMA and the section 12 provides for voidable marriages. Any marriage solemnized whether before or after the commencement of this Act shall be voidable and may be annulled by a decree of nullity on any of the grounds. So now what are these grounds? These grounds are on the ground of impotency, insanity, consent obtained by force or fraud, and pregnancy of the respondent. In these cases, a marriage will be declared as voidable by filing a petition in the appropriate having the jurisdiction of the court. If we want to differentiate in both of them, because we see the general meaning, in what cases a marriage to be declared as void and in what cases a marriage is declared as voidable. So differentiate if we do, the main difference between the void and voidable marriage is that a void marriage is void ab initio. Void ab initio means it is void from the very beginning, from the date of the marriage, occurrence of marriage, it is declared as a void. It is basically void ipso facto, from the very beginning, in limine. A voidable marriage, on the other hand, is a marriage which is valid for all purposes, whatever. It means on the date when you married, it is valid. But in further subsequently events, it is voidable on some grounds or reason. Because it is a marriage which is valid for all purposes, whatever, unless it is annulled by a decree, district court by passing appropriate decree on the petition of the aggrieved party. Second difference is, in the case of a void marriage, the decree declares the status, and in a case of voidable marriage, the decree changes the status. In a void marriage, no rights or obligations are created between the parties which arise normally in lawful marriages as a void marriage, which stands nullified from the very beginning, and either party to a marriage can move the petition to have it declared void, whereas in voidable marriage only the aggrieved party can file a petition for nullity of marriage. In a void marriage, it is open to the party even without recourse to the court to treat it as a nullity, and neither party is under an obligation to seek a declaration of nullity. A voidable marriage is regarded by the court as valid and subsisting marriage until the decree of nullity is obtained during the lifetime of the party. So basically these are the four differences between void marriage and voidable marriage under section 11 and 12 of the Hindu Marriage Act 1955. So friends, I hope you like this video, informative for you, and if you have any query in your mind, please don't forget to subscribe to our channel and mention your query in the comment box. We will definitely respond as soon as possible. Thanks for watching this topic.